Hello and welcome to this ETV Bharat special. We have seen the arrest of the young climate activist Disha, but there is a lot of legal questions that have been asked with regards to the procedure of the entire arrest. Now, we are joined in by senior lawyer, Ms. Rebecca John, who will in fact tell us about the entire procedure that has been put in place with regards to a proper arrest and whether it has been followed with regards to the arrest of Disha. Welcome to the show, ma'am.
Thank you.
When you look at the entire arrest that has taken with regards to Disha, you have in fact criticized the lapses in the procedure. What are the lapses that has occurred?
There are two things, and I would like to clarify that at the start. One is illegality, and the other is impropriety. Was the police did it commit any illegality in arresting Disha? Well, they have the powers of arrest. It is a non-bailable case. It's a cognizable offense, and so that you can't really challenge the power of arrest. It exists. Should they have exercised that power so soon after commencing investigation is a question that is out for the jury. I believe they could have waited. They could have collected more material because in their remand application, which they moved before the Metropolitan Magistrate yesterday, they are talking about recovery of deleted data, etc., which is not something that this young lady can provide. It is for forensic experts to sit together and give to the investigating team. So did you arrest prematurely? Perhaps you did. Now, was the police right in arresting her and producing her before a magistrate in Delhi without going through a transit remand procedure in Bangalore? Again, it was not illegal, but it was improper.
What is this transit remand? Because many of them,
Yes, I'll just explain. So if an FIR has been registered in Delhi and the police in Delhi is investigating the case, but one of the accused persons resides outside the territorial jurisdictions of Delhi, for example, in this case, Bangalore, and the police goes to Bangalore for purposes of investigating the crime and interrogating the suspect and decides to arrest the suspect, then propriety demands that the police must produce the suspect before a local court of jurisdiction in Bangalore before flying her out to Delhi. And that local court in Bangalore will give her what is known as a transit remand, that you are taking this suspect out of our jurisdiction to another jurisdiction till such time that the magistrate with jurisdiction does not remand her. Here is a transit remand order, which will facilitate a magistrate with jurisdiction to look into the case and decide whether or not to remand the accused further or not. So that is known as transit remand. It always happens when you are making an outstation arrest. Now, in this case, this was clearly an outstation arrest. And again, as I said, it is not illegal. There is no term called transit remand, which is used in the Code of Criminal Procedure, but it is a practice, it is a good practice which has developed over time, which is endorsed by several judgments of high courts as well as the Supreme Court. That when you're arresting a person who's out of your jurisdiction, you must go to the magistrate of his or her jurisdiction, take a transit remand, and then produce her to a court with jurisdiction. The Delhi police did not do that. So I believe that was an act of impropriety. It ought to have done so more particularly because in December 2019, a division bench of the Delhi High Court had said that when you are arresting people outside your jurisdiction, you must, as far as possible, obtain transit remand unless there are compelling reasons not to do so. Now, if there were compelling reasons not to produce her before a transit magistrate in Bangalore, did the Delhi police inform the Delhi court about those compelling reasons? What are those compelling reasons? We do not know. So the law is really adherence to the letter of the law as well as the spirit of the law. And the spirit of the law in this case was violated, if not the letter. And that should not have been done. So that was my second critique. Thirdly, I am opposed to, and I'm fundamentally opposed to weekend arrests and productions. It actually places an accused person in a disadvantageous position because When you arrest someone on a Saturday and produce that person on a Sunday, the system is not working the way it works on normal working days. And it becomes very, very difficult for even lawyers of choice to appear before duty magistrates, because you have no idea when the production will take place, where it will take place. And what happened yesterday is a routine example of what normally happens in this confusion, where the lawyer of choice was unable to reach the court, and Disha was represented by a legal aid counsel who obviously knew nothing about the matter. So again, it's not lip service to the law, but it is substantive adherence to the law that we must encourage. Why wasn't Disha's lawyer told in advance that she would be produced before Magistrate X at time Y? And if after that information was circulated to him, if he didn't appear, then of course you bear the consequences of that. But you don't even tell him that. So it's this cat and mouse game which goes on, where both sides are trying to figure out when the production will happen and at what time it will happen. And that is why the lawyer of choice, and that is what Article 22 of the Constitution of India speaks of. It's a constitutional mandate, and Article 22, for the benefit of your viewers, states that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Now, Disha had a counsel of choice. But because you produced her before a magistrate on a Sunday, where the normal rules of production don't apply, and because you did not inform her lawyer of choice the time of production, he was not available to oppose the police's request for police remand. And that, to my mind, is an unnecessary situation that was created. Heavens would not have collapsed if the counsel of choice was present at the hearing and was given an opportunity to oppose Disha's police custody remand. If after listening to the counsel, the court felt that the police custody remand was justified, the court was well within its rights to pass the very same order. But adherence to procedure is something that we must never forget, particularly when personal liberty is at stake.
Well, quite interesting. You said there's a cat and mouse game when it comes to finding out which court the particular person is going to be produced. Now, that also says that the Delhi police seems to have an intent to keep the person at a disadvantage. Now, is it too much if I go to say that there was an attempt to keep Disha at a disadvantage?
Well, I wouldn't say this was the only occasion that has happened. I've been practicing for 34 years in Delhi, and this is something we grapple with always. This lack of communication between the police and the defense lawyer, between court staff and the defense lawyer. And I think the time has come when courts take this seriously, and a protocol is put into place. If you're going to produce somebody on a Sunday before a particular magistrate, you must inform counsel of choice the time of such production and the place of such production. I say so because this is happening repeatedly. A Sunday before last Sunday, a journalist who had been arrested during the farmers' protests, a journalist called Mr. Punia. Now, the production was on a Sunday. The counsel was told that he would be produced in a particular court in Delhi, which is Rohini courts. He goes to that court at the assigned time, only to find out that the police was now producing the accused person within the court complex in Tihar jail. By the time he reaches Tihar jail, which is some distance away, the production had already happened, and he was unable to even move an application for bail and oppose the remand. Now, these are situations which are avoidable, which are unnecessary. You might end up winning one day, but as it happened with Mr. Punia's case, he did get bail 3 days later. The idea is to put into place a system which is transparent, which respects the letter and the spirit of the law. I am not for a minute challenging the police's right to arrest. I am not challenging its right to seek remand. All of that is within its legal powers. Whether it is a sustainable request or not is something for the court to decide. But they have the absolute right to ask for remand when they produce someone after arrest. Certain courtesies, which now must become formalized into our system, is required, and it is that lack of adherence to the spirit of the law which I have tremendous problems with. And that is what happened yesterday, and that is why I think many of us were deeply troubled with the manner in which a young woman was remanded to police custody for 5 days.
Well, interestingly enough, one more thing that has surfaced from this particular arrest is also with regards to sedition. Now, there have been several others like comedians and others who have the voice of dissent. The cases tend to move from a situation where it could be an inappropriate comments to sedition. Now, this transition is made. Can you tell us more about how it becomes sedition and what sedition can be defined as?
We've I've appeared in many of these cases, and I think a lot of these arrests are made despite the fact that there is a Constitution Bench judgment of the Supreme Court of the 1960s, where the Supreme Court has made it clear that simply because somebody is protesting or simply because somebody is raising his or her voice, even against the established government of the day, that is not seditious. Protest is every Indian citizen's constitutional right. Freedom of speech and expression is every Indian citizen's constitutional right. So long as you do not indulge in violence, so long as your remarks do not have a propensity to violence, the act is not seditious. There have been cases in the 90s where terrorists have raised slogans, and yet the Supreme Court has quashed proceedings on the ground that this is not seditious. They have the right to raise slogans. They may be unpalatable slogans. You may not like it, but that does not come within the purview of sedition. As you know, most civilized democracies of the world have abolished this provision. And this is one of the relics of our colonial past. We continue to hang on to it. And it's really a matter of deep concern that a country which claims to be a robust democracy in 21st century world must hang on to provisions like sedition and must seek to prosecute its youngest citizens for acts of sedition. I think that's very, very tragic.
Well, thank you, Rebecca John, for giving us your opinion on this. It's been great speaking to you. That's all for now in the special show for ETV Bharat.